Ladies and gentlemen, what a way to end this year. We got the Commodores that's going to be playing in my background because I need my music. But you guys don't need to hear about how he wishes the world was. Oh, he's going to talk about being a foolish dreamer. The world truly being happy comes later. Ladies and gentlemen, we got some things we need to discuss. So I want you to do me a favor. And you know, I do ask for things from time to time. So the only thing I'm asking for you to do is just clear your mind of everything else. Put the video on pause if you need to. Discontinue all other activities, movements, all of that, because you're going to need to see this. This is dealing with the contracts and understanding how the contracts work. We're going to take that moment to explain to you. A lot of people have been asking, oh, what? How do I fill out this? And what do I do here? And what do I write there? Ladies and gentlemen, I cannot tell you, nor can the organizations that I put together tell you how to fill out the contracts. The POA, the contracts, we can't tell you how to do those. Do you understand that? You have to already understand. So what we will do is we will put out tutorials showing people what can be filled out in certain areas of the document. What is a possibility to place in certain areas. We'll put those out as soon as possible, but there is a lot going on, ladies and gentlemen, and that is why this video is being done, because we're about to highlight how much stuff is going on. Are you ready for us to show you how much stuff is going on? The other day we showed you guys, hold on, gotta show it to you. We showed you guys this document, and this was a contract. Well, it's involving a contract with a telecommunications company. And what you guys may not know is this is a motion to compel arbitration and to dismiss whatever pending case is going on. So let's say this is not involving a telecommunications company. Let's say this is involving a foreclosure. And remember, you guys need to understand, certain foreclosure agreements have arbitration clauses. Your mortgage agreement is a private contract. The courts have nothing to do with that. The government has nothing to do with your mortgage agreement. It's between you and a private corporation, a bank. Still a private corporation. How do we know it's a private corporation? Because the law recognizes that even if the corporation is under a United States federal agency, such as the FD, what is that? The Federal Food and Drug Administration? No, not the Federal Food and the Agriculture. See, sorry. The Agriculture Department for the United States, and I can't even come up with the names for the agriculture, and I apologize for that. I can't even come up with the acronym. But anyway, the Agriculture Department, or the Department of Agriculture. Federal FD. Nope, can't come up with it right now. My mind is on so much stuff right now, so I apologize. And I got my boys in the background, the Commodores. Now, ladies and gentlemen, what is a Commodore? That's right. That's what they named themselves out of, and that's after. But that's how you know it was the 70s. Now, this is the part that I was talking about earlier. That's what I was talking about. Now, that's what I'm talking about. I wish the world was truly happy, but it's not possible for the world to be happy when stuff like this continues to go on. So, ladies and gentlemen, what's been going on that you guys didn't know? Well, let's say this was a mortgage foreclosure. It is a private company against a private party. It's a private contract. What happens is they'll send you, pay attention, a notice telling you have a certain amount of time to pay everything up front, or they will start foreclosure proceedings on you. Hold on, because many of you are not getting this. They've just sent you a notice of change in terms and conditions. Hold on. F. CHANGE. No, let's not do change. Let's do terms and conditions. TERMS and CONDI. We're just going to do terms and conditions, if it'll let me find it. Okay. Frontier notified the plaintiffs that an arbitration provision was being added. An arbitration provision was being added to its internet service terms and conditions. Pay attention. This wasn't part of the original contract, ladies and gentlemen. So we're doing the same thing. We're doing a notice of change in terms of condition that we're calling a conditional acceptance. The exact same thing. Okay? Our agreement says that any and all disputes must be handled through arbitration, the same as theirs, as material condition for receiving the internet service from Frontier. So as a material condition for continuing to be able to contract with me, each plaintiff had repeatedly assented to arbitrate any and all disputes. So they notified the plaintiff that they were adding an arbitration provision. You know, the plaintiffs could have said, no, we don't accept those terms. We are going to continue to abide by the original contract. They didn't do that. And so what did Frontier do? Uh-oh, got to get rid of that. Got to get my hand. Get my hand. Got to get my hand. See, that's my hand, y'all. Okay, they notified the plaintiff of the arbitration provision was being revised in a manner that would make the arbitration not only less expensive, because that's the point. Now, the first thing the mortgage companies want to say is, Your Honor, we're losing so much money. We're being harmed by the fact that they're not paying us. And so we need to get payment, Your Honor. Say, no, they're not being harmed because arbitration is a less expensive avenue. And it's also simpler and more convenient for the parties to resolve their disputes. In addition, each plaintiff was sent a copy of the then current internet service terms and conditions, including the revised arbitration provision, despite being repeatedly informed. See, all you have to do is inform the party of the arbitration provision. The plaintiffs and no plaintiff had terminated services, nor did, or to this day, none has. The plaintiffs have therefore accepted the provisions of Frontier Services, and they are contractually bound by it. Ladies and gentlemen, these are simple, basic principles of law. I did not have this, so guess what? We're going to talk about the case law that talks about notice. Okay? Now, moreover, in proposing the arbitration provision to its customers, Frontier took particular care to assure that the features were even-handed. Okay? Same thing that we're doing, ladies and gentlemen, with our document. Now, because the arbitration provisions are valid and enforceable under the Federal Arbitration Act, the plaintiffs must resolve their claims in individual arbitrations, and this civil action should be dismissed or stayed. That's what they're saying next. Ladies and gentlemen, it is the same thing. We're doing the exact same thing. We told you before that you have the right to do a notice of change in terms of conditions. If you have done that before, the only problem is you didn't have an arbitration clause. We have included the notice of change in terms of conditions in the contract. Okay? And we made the contract irrevocable. What does that mean? That means that they cannot sit up there and come back at you later talking about they're going to try to change it or make it different or change it to this or change it to that. We make it to where it can't be changed from that point on. It becomes an irrevocable contract and it protects both parties. That's the whole point. It has to be even-handed. It cannot be one-sided. That's why they're highlighting that. But they know, Frontier knows that people don't read that junk they receive in the mail. They don't read that. Okay? And if they did, they'd be in a much better position. But the problem is, because they don't take the time to read it, they acquiesce. Okay? Give me 1 second. These terms are posted, so they didn't tell people they post them on the website, and that's because they've seen the other cases where just posting them on the site is not enough. But they post them on the site, and they also send you a copy. That way, they can say that you had notice. But they attach, pay attention, it says received a monthly bill stating Attention Frontier high-speed internet user. Frontier is providing high-speed internet service to its end user customer pursuant to the terms and conditions described here. In the past, Frontier filed this information with the Federal Communications Commission. As a result of recent FCC rulings, we are now providing high-speed internet per these terms and conditions. If you have any questions, please call customer service number that's on your bill. And that's what they sent to everybody. Okay, now you see how they have all of those terms and condition things. So let's find out. Let's go back up. This is the section that I'm looking for. It's in the other document, but I needed to have this. Now, it says, no, not there. That's not the one. Including limitations of liability and early termination fees. And here's the part. These are the information, dockets, location. In short, the plaintiff's contractual rights and obligations are defined by Frontier's. Wait, their rights and obligations are defined by Frontier? That's right, just like our contract define the rights of the individual. Among these terms and conditions is one permitting Frontier to propose changes to the contract. Do you see that? Interesting. A version of that clause is right there, and our right to make changes. See, unless otherwise prohibited by law, and it's not prohibited by law, why isn't it prohibited by law? In accordance with this change in terms and condition, on September 11th, Frontier posted the terms and conditions, which included an arbitration provision, on its website. Frontier also sent to the customers and the plaintiff the information letting them know about the change in terms and conditions. Then it let them know that if they had any problems, that the provisions would take place 45 days after the date of the bill. What they said is that the individuals, if they were to pay a bill from that point on, it would document their accepting the service. So let's go that. Let's find that. Let's see if I can find the acceptance. Conversely, in reliance on the plaintiff's acceptance of the terms and conditions, Frontier provided the plaintiffs and price of service at a very affordable cost. So I'm looking for the case law associated with that. One who has accepted the benefits under a contract is regarded as having ratified the agreement. Hello? Hold on. Did y'all just see that? This is what the courts have held. This is why you guys are getting into these contracts and you don't even recognize what's happening. They're sending you this stuff in the mail and you don't even recognize it. You have no clue as to what they're doing. They're sending you this junk in the mail. They're changing the terms and conditions, and this is why you're losing in court. This is why you're losing your homes. This is why you are losing when you are having a debt that you have to take care of, because they're changing terms and conditions and you're not responding. So pay attention. Similarly, as the Seventh Circuit has explained, a vendor as master of the offer may invite acceptance by conduct of terms provided with delivered goods by the buyer's failure to cancel the transaction. Now hold on. Here, not only did the plaintiff accept the benefits of their contract by choosing to maintain service, they affirmatively and repeatedly chose to continue paying for service after they were informed on their bills that service was subject to acceptance of Frontier's terms and conditions, including the arbitration provision. Now, what happened next? For these reasons, the Federal District Court of Minnesota recently held that under Hill Frontier, revised terms and conditions, including the arbitration provision, applied to customers who continued to receive service after being notified of the revised terms and chose not to terminate their contract. That's what the courts just said, is what they're highlighting. Ladies and gentlemen, we're doing the exact same thing. Now hold on. It did the same with respects to the revised arbitration provisions posted posting its contents on the website and providing each plaintiff with notice by bill message on blah blah blah. So they gave them notice. You guys have seen the law where the Supreme Court has said that the only thing that need happen is a party be notified. Okay? That's all this is about, is notification. That is all this is about, is notification. All right, now that we got the notification out of the way, now that we got the fact that all a party has to do is notify the other party of change in terms of condition, I believe in one thing: equal protection of law. Don't you believe in that? Man, that is your best friend. You have the due process and equal protection clauses. Those were the two clauses that I started studying when I started understanding law. Now, although the courts want to interpret what this means, what that means, what due process isn't, ladies and gentlemen, the due process and equal protection laws were created under common law. They were not created under statutory law. That's why there were no statutes at bay that told people how they worked. Just that simple. Just want to make sure y'all understand. Equal protection, due process are common law rights. The same as arbitration is a common law right. Arbitration is a thing that people go through. Hold on, we got one more thing to show you. Privately, dealing with private contracts. Okay. Hold on. Gotta find it. Not worried about the printing things on the website. Ladies and gentlemen, what's happening, so that all of you get it, when we send out our contracts, we are giving them notice that we're accepting their terms and conditions under the following terms and conditions. Now it says this: the most important reason why the agreement was enforceable was that Frontier's 45-day notice on the bill provided its customers with constructive, if not actual, notice that an arbitration clause would be added to Frontier's terms and conditions. Are you following me? Well, we give notice. We let them know that we're adding, if they choose not to respond, we're adding the arbitration clause. Now, Frontier's customers who continued their service and failed to terminate their service despite the notice thereby accepted the terms and conditions, namely the addition of the arbitration, which means they were now going to force people to go through arbitration. The court rejected the plaintiff's argument that the change was invalid because the change in terms did not appear on the face of the bill. And that's absolutely correct. It does not have to appear on the face of the bill. The law only requires that you receive notice. Okay? That's all the law requires. So, told you I wanted you to focus, so let's focus, ladies and gentlemen. This is the same agreement. I had problems transferring it to this document, but this is everything that's in that agreement. It's all here. I just have to reword it to fit the situation so that we can put this up for people who have cases that are pending, because you will have to do, yeah, I got to get rid of that J. That's what happens when you transfer something. Sometimes the words aren't, it's supposed to be under these rules, not supposed to be all one word. So I'll be taking care of this later. This is RI. I'll be taking care of all of this later. What I need to express to all of you, so we're going to break it down like Tevin Campbell said, and we're going to explain it to you so that you get it. And we're going to try to do it quickly without going quickly. In our society, the government is constantly giving you papers with a lot of fine print. You're getting these big, huge packets in the mail from these companies, and you are not reading it. But what you don't realize is they're giving you notice. Now, again, I can tell you how to get around those notices, but the same information can be used for getting around our contracts. And so I can't say it out loud to you. I can't even say it in private because I'm not going to do that. What I can say is that Mr. Bradley Christopher Starks is a genius because he figured it out. And when he figured it out, coincidentally, one of the people that he was working with happened to have watched one of my videos and said to himself, this guy knows what he's talking about. I'm going to reach out to him, and went out of his way to find my number and call me. It just so happens that while driving, and I was at the location I am now, while driving, I'm on the freeway, and I'm telling him I'm on my way to Walmart, and I decided to answer the call. Normally, I don't answer these calls. What could I do for you? And he started explaining, and I told Demetrius, I said, and I've told him this several times afterwards, that I don't believe it's a coincidence that you called me and I actually happened to have answered your call. He says he considers me to be a friend. Tells me no matter what. And I told him that I will break my neck to help Mr. Starks. See, Mr. Starks didn't have all of the pieces to his puzzle. But I did. I had the remaining pieces. He had pieces I didn't have, and I needed, and I had pieces that he needs and he didn't have. Bringing those two Rubik's cubes together, we're creating a mega cube. Okay? So, when he brought it to my attention, he told me that they had wrote a contract with the United States government. Let's see if I can pull up that, because I need to go here. And when I go here, I need to go, I think it's this one. Come on. No, this is arbitration. This might still be arbitration. Let's see. Yeah, that's the enforcement of an award. I gotta find it. So I'm gonna have to put you guys on pause. You know what? My phone, my music stopped. And now, yeah, we're gonna listen to some other music. Some instrumental stuff. That's for me, not for you guys. I gotta find one particular case. So no, these are not the ones I'm looking for, Chief. Let's go here. Yeah, let me put you guys on pause and we'll come right back and I'll show you where I'm headed, where I'm going, how I got there, and why I'm there. Okay, so give me one moment. Ladies and gentlemen, I was looking for something a whole lot more than this, but I don't need this. I can just go to this video by this idiot right here and I can show you. Okay? On April 23rd, 2018, the courts held the corporation was distinct from the United States and did not share its immunity. When the government is acting under its corporate or administrative capacity, it has no immunity. But our government is a corporation. That's right. Every government is a corporation. The only difference is when they operate in commercial business, okay, that's where they are killed, destroyed. And so when you guys get a chance, this is the one you want to look at and you want to study this. That's your biggest and bestest friend. Now in Salas versus U.S., 1916, when the United States enters into commercial business, it abandons willfully, it waives sovereign capacity, and is to be treated like any other corporation. The moment they do commerce, well, Congress gets to determine what interstate commerce is and interstate commerce isn't. That's right. But they don't get to immune themselves because, pay attention, the court cannot find any reason to depart from this principle. This is a principle. It's a maxim, people. Take the federal government. When the federal government chooses to act through a state incorporated entity, courts hold those corporations to be just what they appear to be and subject to suit under the terms specified by state law. What do they appear to be? Private corporations. That's what their CAFRs show. Okay? And all you need is this information right here to protect you. Okay, it's right here underneath the video. What video? We just showed it to you. I wish you guys would stop that. messing up my day, messing up my flow. That's Anthony David in the background. Anthony David, Davis, sorry. Anthony Davis is an artist who I stumbled across and finally proof the government engages in commercial business. Okay, that's the one. That's the video. Okay, so that's the video. And where's my mouse? Okay, there she is. It's giving me a headache, ladies and gentlemen, because I can't scroll because my screen is saying, nah, y'all ain't going nowhere. So let me reduce the size of the screen. Look at that. Now it won't act right. Come on now. All right. You know what? I got my mouse that I can use to make it bigger, smaller. Okay, that's what I was trying to do. I used the mouse to do it that time. And let's see if I can bring it up. I may have to pause y'all because it is a video card issue. 1 second. Look at that. Won't even let me do that. Come on now. That's what I get for trying to do too many things at once. Trying to show you guys this information. The whole screen has paused because this is still trying to get to that site. So it's going to be a second. And then I'm looking at my my internet speed, and that junk is horrible. So let's just say I'm not surprised that I'm having problems with what I'm trying to do right now. 1 second. Okay, we had a wardrobe malfunction, so I apologize for that. Let's finish reading this. And so if, as here, the state in question conditions the privilege of creating a corporation or a corporate entity under its laws on an agreement, the new entity will be amendable to suit. And guess what? The United States is amendable to suit when it operates as a corporation. That condition must be respected even when the incorporator, the federal government, is the one who is making it amendable to suit. One sovereign, after all, cannot usually rewrite the laws for another. What do you mean usually? Hold on. One sovereign, after all, cannot usually rewrite the laws for another? What the? If the federal sovereign thus chooses as its agent a state corporation which can be sued, it cannot by ipse dicta deprive one injured by such agent from the right to sue. Here's your buddy. You want to use this? This lets you know you can sue them corporations associated with the federal government. They always say you can't sue the Department of Agriculture. See, that's what I couldn't remember before. The United States, the USDA, the United States Department of Agriculture just wasn't coming to me. Just the way the brain works, too many things on it. When the United States enters into commercial business under the laws of New York, it is to be treated as any other corporation. That's the laws of every state, ladies and gentlemen. The reason why you usually see New York is because most corporate law stems from New York, just like most trust law stem from New York. The same principle holds for foreign sovereigns. At common law, a foreign government's decision to incorporate a business under a state's commercial laws didn't afford the business immunity, but subjected it to suit according to the terms prescribed by state law. When a foreign government becomes a stockholder in a state corporation, it does not exercise its sovereignty as such, as the corporation. It acts merely as a corporateur and exercises no other power in the management of the affairs of the corporation than are expressly given by law, state law, for corporations in their Incorporating Act. Restatement second of Foreign Relations Law. And this long-standing common law rule, this long-standing common law rule has now been deliberately codified in the Foreign Sovereign Immunities Act. Ladies and gentlemen, this is Miss Dana Owens. Okay. I'm kind of mad at Dana. Oh, Queen Latifah, I apologize. That's Queen Latifah's name that she went under when she did the song. That's her actual name. Her rap name was Latifah, Queen Latifah. But for the album that she did called the Dana Owens album, that was the name she went by. We're going to talk about her at a different time because she gets on my nerves now. All right. Even a state is generally held by the terms of its own corporate laws when it chooses to incorporate an entity. See, this is what the Bank of U.S. Implanters, this is what they said. The state is bound. But there's something else I want to show you in that case. We're going to go there in a minute. It says, to be sure, a state may enact laws allowing the creation of a governmentally owned special purpose public corporations, typically to perform chores comparable to that of a government agency, like running a port authority or a university. Nothing in the sovereign immunity extends only to those state-owned corporations, both immune as a matter of state law and performing typical state functions. Noting that the sovereign immunity extends only to those state-owned corporations, both immune as a matter of state law and performing typical state functions. Ladies and gentlemen, that is not true. And they know it is not true. That is a quote-unquote, pay attention, that is a thing that they added because of presumption of law. Because this is a presumption. That's why it says noting that the immunity extends. Okay, that was a decision. Okay, I guarantee when we go there, oh, this is 2008. See, this is 2008. Okay, again, this is a presumption of law issue. And to be sure, those public corporations are sometimes treated as arms of the state and endowed with sovereign immunity. Again, later cases, that is not true. They cannot be arms of the state if they're privately owned. They want to call them public corporations, and you will hear that all the time. They'll refer to something as being a public corporation when it is not. That's why they're CAFRs. Okay? Thank you, Mr. Clint Richardson. The CAFRs, the Comprehensive Annual Financial Reports, is the issue. That's how you stop all of that stupidity. Because the Comprehensive Annual Financial Reports prove one thing only, that they are a state corporation. Okay, Dana, thank you for your being a mighty long time. Because she just said it seemed like a mighty long time. Now, we're going to talk about sometimes when you sit down and you write a letter, sometimes that letter can be a little bit long. And then people can ask you to keep turning up the volume. And they just beg you to keep turning up the volume. Ladies and gentlemen, the late Aaliyah, singer cut down in the midst of her prime. Okay, we're going to let Aaliyah play in my background. Like I said, that's for me. Let's get back to explaining this. And I know that I've gotten your attention for a moment. And like I said, with me, you need to understand, if you can get past the first 15 minutes, then you have done great. Okay? So let's continue. Questioning the wisdom of this development. Now look at that. Williams J. concurring, but questioning the wisdom of this development. That's right. Because what did they do? They changed it. Okay? The law didn't change. They changed it based on presumption. There is no suggestion that an arm of the state public corporation like this is ever created under Oklahoma's general incorporation statutes. Applicability of a statute to the sovereign depends on context, subject matter, legislative history, and executive interpretation, let alone on behalf of another sovereign. Ladies and gentlemen, let me make sure you understand. They cannot create a corporation that is government owned under state law, because that means the corporation has to abide by state law. Pay attention, which means the corporation is not sovereign. You must understand the United States government and the agencies of government in the United States are not sovereign. How? How can we prove they're not sovereign? Because they are limited. The sovereign is not limited. The sovereign is never limited. The sovereign has all power to do whatever the sovereign chooses to do. Why do you think Germany could kill the people it was killing? The only time it was restricted was under its corporate charter with the, pay attention, League of Nations, because it was a member of the League of Nations. Saddam Hussein, when they claim he was doing all of those so-called atrocities, the same atrocities the United States did to its people with Agent Orange and mustard gas and all of those tests that they did on people, the syphilis that they did on the people in Guatemala, the children in Guatemala, testing them with syphilis, and that the U.S. government, including Hillary Clinton, knew this. That they knew this, that Hillary Clinton, as Secretary of State for the Obama administration, apologized 40 years after they did it. These people are in their 50s and 60s with syphilis, if not many of them have already died. And they want to apologize? What the? I apologize. Let's get rid of this, and we're going to go to this. Don't care nothing about this stuff right here. Nobody asked anything about nail design. Nobody asked anything about facial moisturizers. None of my searches, they're talking about search recommendation. Ladies and gentlemen, that is Google and its stupid advertisement. And none of that has anything to do with any of my searches. I'm talking about the Bank of the United States versus Planters Bank. I don't see no peanuts over there. Okay? I don't see not a single Planters peanut jar or anything over here talking about recommendation. All right, let's continue. We're going to go to Justia. There is something I need to show you about government, and I promise you, let me go ahead and put you guys on pause, and then I'll just take you there instead of searching for it. 1 second. Ladies and gentlemen, before I end this video, and I really hate this because it was supposed to be short, but I just came to some information and a conclusion that I need to share with all of you. But the moment I turn the screen back on, I can't get to where I need to. I need to show you all this right here, what the Supreme Court is saying. Now, someone brought a suit. The Bank of the United States brought a suit against Planters Bank of Georgia. Now, the Bank of the United States brought a suit, and what the Planters Bank of Georgia said is that, hey, you can't sue us. We're part of the sovereign. Okay. As a state, be a party of the record. A suit against Planters Bank of Georgia is no more than a suit against the state of Georgia. Then no more a suit against the state of Georgia than any other individual corporator. The state is not a party. That is an entire party in this cause. Ladies and gentlemen, we all know that the government is de facto. We know that it is not the original government, which means they are not protected by the 11th Amendment, even if it was government. I just thought I'd highlight that, because they themselves recognize themselves to be de facto. They themselves recognize the suspension of the Constitution, which means they are not government because they've overstepped the bounds of the limits of that government. They are not government. Okay? So they put themselves in line to be sued. It says if this suit, originally if you sue a government entity, you have to do it in the Supreme Court of the United States. This is what this particular court is saying, that if it wasn't, their court would have no jurisdiction. They would have to go to the United States. Okay? I had to bring that up because some people are wondering. Ladies and gentlemen, All of these are corporations. They all engage in commercial business. They all invested in the stock market. Give me a second. Got to pull up that section that we were talking about. Ladies and gentlemen, this case says so much. But it's an 1824 case. That's right, but it says so much. Pay attention. It says, many states of this union have an interest in banks or other corporations, and notice this, are not suable even in their own courts. Yet they never exempt the corporation from being sued. Pay attention. When the government owns a corporation, they cannot exempt it from being sued. Why? Because equal protection of law says they can't. If they create a corporation, that corporation must operate under the same terms and conditions of every other corporation. Which is why the laws of the state says that a corporation incorporated in that state must be amendable to suit. That's why they must have a registered agent. The state of Georgia, by giving to the bank the capacity to be sued and or to sue, voluntarily strips itself, voluntarily waives all rights, strips itself of its sovereign character so far as respects the transactions of the bank and waives all. Well, remember, the government does, pay attention, transactions, trading of cases on the market, waives all the privileges of that character. As a member of a corporation, the government never exercises its sovereignty. It acts merely as a corporator and exercises no other power in the management of the affairs of the corporation than expressly given by that incorporating act. The government of the Union held shares in the old Bank of the United States, but the privileges of the government were not imparted by that circumstance to that bank. The United States was not a party to suits brought by or against the bank in the sense of the Constitution. So, with respects to the present bank, suits brought against or by it are not understood to be brought by or against the United States. The government, by becoming a corporator, laid down its sovereignty. Lay it down, y'all, so far as respects the transactions of corporations, by exercising no power or privilege which is not derived from the charter. So we think it then that Planters Bank of Georgia is not exempt from being sued. Interesting that it talks about whenever the government engages in transactions of a corporation. Ladies and gentlemen, anytime they are trading a case on the market, they have engaged in transactions of a corporation, and they are not government. They are treated as any other corporation. That's what this case is saying. Don't look at this case as worrying about who is endorsed to and paid to and who is this and who is that. Focus on the fact that the case says that anytime the government engages in transactions, so when they are accepting fees for services, and those fees go toward anything else other than those services, and by the way, remember, you're paying taxes. Your taxes is paying the salaries of those individuals. So why are they charging a fee for service? Because the clerk's office is a private corporation. They are not part of the court. They are a private corporation. Every clerk's office. That's why all of the clerks are deputy clerks. The sheriff's office is a private corporation. That's why every officer is a deputy sheriff. Okay? But a private corporation nonetheless. All right. So I just wanted to explain that. I've been wanting to explain that for days. So let's get back to this video so that all of you can understand it. We're going to have to get you to go back and refocus. So let's take a second. We're not talking about private corporations or anything else right now. We're going to focus on the contract and the arbitration clause. As you have seen, we're going to go here to this document. We're not concerned about this language here. We are concerned about the fact that the individual received a copy of the change in terms of conditions. And as a result of having received a copy of the change in terms of condition, they were prohibited from taking the company to court. Well, ladies and gentlemen, that's the same thing with your document. it has an arbitration clause that says arbitration is the exclusive remedy. Give me 1 second so I can show you that, so that you can see it for yourself. 1 second. Ladies and gentlemen, this is an actual contract. This is an actual agreement that was one of the first ones we did. It speaks about, let's scroll down. Please understand that the undersigned does not desire, nor wishes, nor wants to cause any problems to anybody. We want to resolve this matter as promptly as possible, so we're not trying to delay anything. The undersigned can only do what respond to the respondent's official response to the self-executing binding contractual agreement in the form of a conditional acceptance for value and counteroffer claim of proof of claim by respondents providing the undersigned with the requested necessary proof of claims raised here and above. Therefore, as the undersigned is not a signatory nor a party to your social compact contract known as the Constitution Charter of the United States, nor noticed nor cognizant of any agreement, contract between the United States and the undersigned, specifically due any obtained through full disclosure, and contained in the fair, valuable consideration therein, which would act and operate to create and establish a relationship, nexus, and thereby and therein bind the undersigned to the specific source of authority for the creation and existence of the alleged statutes, laws, as contained and allegedly promulgated within the code known as the United States Code, which, with the brevity of the contract and contracts itself, would thereby and therein create and establish legal force and or effect of said statutes, laws over and upon the undersigned. Ladies and gentlemen, what we're trying to say is we have told all of you that we've included everything. Let's continue. Why you said goodbye? It says, establish legal force laws subject the undersigned to the statutory jurisdiction of the United States, its laws, its venues, jurisdiction, and the like for its commercial courts, administrative tribunal, there you go, commercial courts, administrative tribunals, units, and thereby and therein bind the undersigned to said courts, administrative tribunals, unit decisions, orders, judgments, and the like, and specifically as within the above reference alleged commercial civil cause, and which would act, operate, or establish and confer upon the court, administrative tribunal, unit, and the necessary requirements, essential of subject matter jurisdiction, without which it is powerless to move in any action other than to dismiss. The undersigned once more respectfully requests the respondents provide said necessary proof of claim so as to resolve the undersigned's confusion, I'm so confused, and concern within these matters. Otherwise, the undersigned must ask, what is the undersigned's remedy? They must provide remedy, ladies and gentlemen. The undersigned presumes, assumes, accepts this administrative agreement with its common law provisions held as binding, self-executing, and a contractual agreement as said remedy. This is your remedy! Yay! Anyway, therefore, the respondents have superior knowledge of the laws, access to the requested necessary proof of claims, and otherwise being in the catbird seat. I had to look that up because that was Mr. Starks who added that. To provide the requested necessary proof of claim, it means that they're in a supreme position, prime position, direct position to get the information and to know this information. So they cannot claim they don't know what we're talking about, which is the first thing they do. That's why that's there. Okay, that's why this paragraph is here, so that they cannot claim they didn't know what we were talking about. You'll find that this is in the caveat of the contract. Respondent is able, capable, and most qualified to inform the undersigned of these matters related to and bearing upon and above reference alleged commercial civil cause, and thereby therein clear up all confusions and concerns in said matter for the undersigned as to the nature and cause of said processes, proceedings, and the like, as well as the lawfulness and validity of such, to include inter alia all decisions, orders, and the like within arising from all such within said commercial civil cause. The undersigned herein and hereby provides the respondents, hey, you get 10 days. Why 10 days? Did you see now that people say 30 days? No, they get 10 days. And if they won't mow, they have to request it. Okay? So proof of claim to the undersigned and the below named / third party for the sole purpose of certifying a response for want thereof of the respondents. Further, the undersigned, hold on, herein and hereby extends to the respondents. What are you extending? An olive branch? The offer of an additional 10 calendar days in which to provide the requested necessary proof of claims raised herein and above. If the respondents desire the additional 10 calendar days, the respondents must cause to be transmitted to the undersigned and the below named third party notary a signed written request. Upon receipt thereof, the extension is automatic. However, the undersigned strongly recommends the respondents make requests for the additional 10 days well before the initial 10 calendar days have elapsed to allow for mailing time. Note, should the respondents make a request for the additional 10 days, said request will be deemed good faith on the part of the respondents to perform this offer and provide the requested necessary proof of claim. Should the respondents, upon making a request for additional 10 calendar days, then fail or otherwise refuse to provide the requested or necessary proof of claims, said acts on the part of the respondents shall be deemed an evidence as an attempt of constructive fraud, deception, bad faith, and the like upon the respondent's part, and further attempt to cause and inflict injury upon the undersigned. Further, the undersigned here strongly recommends the respondents that any proof of claim and request for additional 10 days be transmitted by certified mail, return receipt request, and the contents therein under proof of mailing for the good of all concerned. Should the respondents fail or otherwise refuse to provide the requested and necessary proof of claims raised herein and above within the express period of time established and set forth and above, the respondents will have failed to state a claim upon which relief can be granted. Further, the respondents will have agreed and consented through tacit acquiescence to all the facts in relation to the above reference alleged commercial civil cause at common law. Because they just agreed to be under common law, which means that the arbitrator has to operate under common law, which means that if it goes to the court, they have to operate under common law. Why? Well, they don't do common law no more. Yes, they do, because the contract says they have to. They have to go according to the law of the contract. We'll talk about all that stuff later. Let me finish. As raised in here and above is proof of claim herein, and all facts necessary and of consequence arising therefrom are true, and they operate in favor of the undersigned, that said facts shall stand as prima facie ultimate and unrefutable evidence between the parties of this binding self-executing contractual agreement presented as a conditional acceptance for value counteroffer claim of proof of claim. The corporate government judicial construct respondents represent, serves, and all officers, agents, employees, assigns, and the likes in service to the respondents as being undisputed. Further, failure and or refusal of the respondents to provide the requested necessary proof of claim raised here and above shall operate as ratification of the respondents by the respondents of any and all facts stated, set forth, established, and agreed to and upon by the parties to this self-executing, binding, contractual agreement, conditional acceptance for value and counteroffer claim, proof of claim, that are true, complete, and not misleading. Now, here is where we had to read that so that you understand, as we stated, everything is covered. I just had to add in the things that Mr. Starks was unaware of that needed to be added into a contract. So, additionally, it is exigent, sorry, that's my word, exigent, and of consequence for the undersigned to inform the respondents in accordance with and pursuant to the principles and doctrines of clean hands and good faith, that by the respondent's failure or refusal to respond or provide the requested necessary proof of claims raised herein and above, or thereby or therein expressly consent and agreement to said facts, and as a result of the self-executing agreement, the following is contingent upon their failure to respond in good faith with specificity with facts and conclusions of common law to each and every averment, condition, and or claim raised herein, as they operate in favor of the undersigned through tacit acquiescence. The respondents not only expressly affirm the truth and validity of the said facts established and agreed upon between the parties to this binding self-executing contractual agreement, conditional acceptance for value, and counteroffer claim, proof of claim, and the respondents having agreed and consented to, respondents having a duty and obligation to perform and to provide the requested necessary proof of claim raised herein and above, will create and establish for the respondent estoppel in this matter. Meaning they can't bring a suit. They've agreed not to sue. They have agreed, and that's the point, ladies and gentlemen. They have agreed through tacit acquiescence. What's tacit acquiescence? Well, it's when your mama goes to the store and she comes back home with nothing in her hands. And she told you she went to the store when all she did was went to her neighbor's house. You know that neighbor that's your father's best friend? That's tacit acquiescence. Now I'm going to continue, if you don't mind asking such an intelligent question. Ladies and gentlemen, it creates an established estoppel in this matter and all matters related hereto and arising necessarily therefrom. It covers the entire future. Okay, and in accordance with and pursuant to this agreement, a contractually consensual self-executing binding agreement between the parties to this conditional acceptance for value. See, we did a conditional acceptance. In other words, that's our change in terms of the agreement. Okay? And counteroffer claim, proof of claim, to include the corporate government agency department construct whom the respondent represents, serves, as well as all officers, agents, employees, assigns, and the like in the service of the respondents. But you said this is against the bank. What you mean government agency? Because the bank is a government agency. Didn't you just hear what we just read? Okay. Did you not just hear what we just read about the Supreme Court saying that these quasi-agencies, well, all banks are one and the same with the Federal Reserve. You think the Federal Reserve is a private entity, but you notice the Federal Reserve is registered. That's why it has an EIN number. That's how we know that they're under, pay attention, they're under the incorporation laws. They all have EINs. They're not government. But the banks are one and the same with the Federal Reserve. The Federal Reserve is one and the same with the United States because they're an agency. So that's why it says all of that. You following me? Some of you, this is going to ring true, but some of you are going to have to go back and listen to what I just said so that you can pick it up and understand what's going on. Okay? They all have EIN numbers, people. As long as they have an EIN number, they can be sued. Why? Because they're under the incorporation laws of the United States, which means that they must be suable. They cannot be government. And that's all you need is to bring up their CAFRs and their EIN number. Because that means that they are a private corporation. They are not government. They are not sovereign. The sovereign cannot have an employer identification number. Let me say that again. The sovereign cannot have an employer identification number. There you go. Some of you are getting it. So the next time you go to court, ask them for their W-9. You know they have to give you the W-9 when you request it. Ask them for a copy of their W-9. Told you were going to learn something. All right, let me continue, shall we? It says that you, so that you get it, whom the respondent represents, serves, as well as all other officers, agents, employees, assigns, and the like in the service of the respondents, will not argue, controvert, oppose, or otherwise protest any of the facts already agreed upon by the parties set and established herein, and necessarily and as a consequence arising therefrom, in any future remedial proceedings, actions including binding arbitration, the exclusive remedy for settling controversies respecting the self-executing binding contractual agreement between the parties. The exclusive remedy. Okay? That's what Congress highlighted. and confirming the award in the District Court of the United States. Now, you notice we didn't say the United States District Court, did we? That's right. Pay attention. We said the District Court of the United States. The outside of their building says the United States District Court. That's the wrong court. It says, or any competent court of original jurisdiction. Just got to make sure that you understand that. Who has the authority? Okay? And that is confirmation of the award. And see, or at any competent court under original jurisdiction. This is the thing that Mr. Starks did not specify in his document. Because there's only one court in every state that has original jurisdiction. It can extend that jurisdiction to another court because it has the power, because original jurisdiction is the judicial branch of government. Okay? Original jurisdiction for the executive branch is the government branch of government, the executive government branch. The original jurisdiction of Congress is the government branch. The Constitution only recognizes original jurisdiction within a judicial branch with the Supreme Court. Go ahead and look at your Constitution. You'll see no other court is given original jurisdiction. That's why the appeals court that we just read that case was talking about original jurisdiction. Okay, they did that on purpose. In accordance with the Federal Arbitration Act, see, now the reason why most of you may not understand why he mentions the Federal Arbitration Act or is agreed to herein. Ladies and gentlemen, the reason why this is the case is because this is what allows you to have the Arbitration Act and to ask for a stay and all of that. It's because you have to mention the Federal Arbitration Act, wherein this conditional acceptance for value contract number or through a form of the complainant's choosing. See, we added that because we make sure you get to choose. If you don't want to go through arbitration, you get to go through another form of your own choosing. Shall substitute an agreement of all interested parties in the event of a default and acceptance through silence and failure to respond when a request for summary disposition, that's what we're asking for, of any claims or a particular issue may be requested and decided upon by the arbitrator, whereas a designated arbitrator shall be chosen at random who is licensed and duly authorized, and in an event of a non-acceptance of the appointment of an arbitrator and or any physical or mental incapacity to act as arbitrator, the undersigned shall have the authority to select any neutrals or arbitrators that qualify pursuant to state and federal law, and any controversy or claim arising out of or relating in any way to this agreement or with regards to its formation, interpretation, and or breach, and any issues of substantive or procedural arbitrability shall be settled by arbitration, and the arbitrator may hear and decide the controversy upon evidence produced, although a party who is duly notified of the arbitration proceeding did not appear, that the undersigned deems necessary to enforce the good faith of all parties hereto within, without respects to venue, jurisdiction, law, and form, the undersigned deems appropriate, meaning that the undersigned gets to choose the arbitrator. The other documents say that they choose SAA. Okay, that's your choice. Okay? That's the whole point. That's what the document does. Okay? That's what the document does. Then it says further, the respondents agree that the undersigned may secure damages via tort. This is the Court of Claims. Let me see if that's in here. I may have taken that part out. Let's see, because see their document COURT of CLAIMS. Nope. No Court of Claims. So I took the Court of Claims thing out. They had two phases. They had the Court of Claims. And I know what it is. I didn't take it out. They had the Court of Claims in their document in the settlement agreement. We don't want the Court of Claims because that allows somebody else to play around with the funds. Okay? We want the actual order from the arbitrator. We want the confirmation. We want to be able to go directly to the Treasury to get our payment. See, it says further, no, let's not do the tort thing because that's not the important thing. Now, if you see this one, estimated $500 million, okay, again, that's because of the value of the property. There's 17 different entities associated with this contract and 14 different properties, all valued over $1 million each. And these individuals have taken several properties after paying to the borrower credits, book entry credits, and never telling the borrower about the book entry credits. But that's another story, another thing. We just wanted to explain to you, because some of you are misunderstanding, that the contracts have everything they need. This process is 100% legal. There is no, well, you didn't do this and you didn't do that. I assure you, because we have covered all of the bases, okay? Including the notice of fault, opportunity to cure, okay? And then people, they see this all capital name thing. I left that in there on purpose. Why? Because we know that every contract, driver's license with government, they place your name in all capital letters. Well, you gave them that name. They didn't give that to you. You provided that name to them in the first instance. Either your parents did or you did. In school, they asked you, what was your name? You gave that to them. You never gave them permission to do whatever they wanted to with your stuff. It belongs to you. It does not belong to them. We were saying in the past that they created it. No, they didn't create it. You see, that's an infringement, the same as, pay attention. This is called More Than Words. You guys know this song? I think Seal did this song at one point, and there have been several other singers. This is Anthony Davis again, and he's with Miss Ari, okay? And so, oh no, this is Something About You. I'm sorry, they did this song plus More Than Words. I apologize. This is Something About You. So let's talk about Something About You. And no, this is what Sequoia. Okay, but anyway, Anthony Davis and Something About You. So let's just say I take that exact song, and the only thing I say in the song, I just change it to be something about me. And I take the title and I put it in all lowercase letters, and instead of the song being in all treble, I take it and I put it in all bass. And then I call it mine. Ladies, you can't do that. Gentlemen, you can't do that. That's illegal. You can't take somebody else's property and then change it around and make it look like it was yours, like you created it. I know the United States does that all the time, like with the car and the telephone and the electric light bulb. That's what they do, but that's illegal. Which is why you mention all throughout the contract that such things are illegal. That's why you put all the case law up there proving that it's illegal. That's what we're doing, ladies and gentlemen. So, let me tell you why I did this video, and then we're going to conclude this video. When we came to this form, I was looking over this form and I was going over it, and I'm like, wait a minute. They're actually admitting this and actually admitting that. See? I don't want the First Amendment complaint because I haven't gotten to that part yet. I got to wait for that little spiraling thing. It's like it's refreshing, so I got, oh, it's so refreshing. I got to wait for it to stop refreshing. So it'll be 1 second. Come on now. It's just going to give me a hard time, law. But watch this. Ladies and gentlemen, I want you all to understand this is the section I was looking for. It says that they had an opportunity to opt out of the arbitration if he or she wishes. It says, one who has accepted the benefits under a contract is regarded as having ratified the agreement. In your contract, they accept the benefits by not responding, by not agreeing. We put in there, we highlight that the individual is not an infant, not a minor, is completely competent, sitting in that cat's bird seat, and fully aware of what a contract is. Why? That's why they cannot sit up there and claim stupidity or ignorance. You know how they like to do? Well, we don't understand what you're asking for. We cannot understand the information, and asking you to explain it even more? Nope, you don't have to do that. The contract is the contract, and they're stuck with the contract. Just that simple. And so the law holds the same thing. It says similarly, the Seventh Circuit has explained a principle of law. A vendor has master of the offer. As master of the offer. Well, guess what? Their original offer, they were the masters of. But when we did our counter offer, we became the master of the offer. And you just have to understand the way the law works. We were the offerer. We did a conditional acceptance and counter offer. We may invite acceptance by conduct. In other words, you don't respond, that conduct illustrates that you've accepted. However, of terms provided with delivery of goods by the buyer's failure to cancel the contract. Okay? So they have their avenue. And we're doing the same thing to them that they're doing to us. Okay? Just that simple. They are doing it to us. We're doing it to them. We're doing these, what do you call these contracts? And especially in this situation, do you notice that the company, the telephone company, the telecommunications company never signed anything? They just sent them a notice of change in terms. Didn't even put a signature there. Go ahead and look at the document. Look at the contracts they send out to people. There's no signature. Now, guess what? Some of you people need to be bringing that up when you're dealing with their arbitration provisions. Say, this provision right here is not signed by anybody. This is not an agreement. It's just a piece of paper with words on it. Yeah, it has their name on it, but it doesn't have any signature. And it would require a signature in order for this agreement to be binding. Not a signature from me. No, a signature from the original offerer. See, corporations must have an authorized agent sign that document. And they can't do an electronic signature because they're not sending it to you electronically. I know. Nobody thinks like me. Okay? Some of you guys who understand contract law will understand that and be able to take that and make something of it. Okay? Just thought about it just now. Okay, for these reasons, the Federal District Court of Minnesota recently held that under Hill, Frontier's revised terms and conditions, including its arbitration provision, apply to customers who continue to receive its services. Ladies and gentlemen, they just received it. They just didn't respond. Wait a minute. So how could it apply to them if they just simply didn't respond? Because they received notice. And the law only requires that a party be notified and can choose for themselves. You have to give them the choice of responding or not responding. That's what our document does. It gives them the choice. Okay? You must give choice. All right, ladies and gentlemen, sorry to be keeping you guys all this time. This is an hour and 12 minutes. I wasn't planning on taking an hour and 12 minutes. I just wanted to show you the genius of Mr. Bradley Christopher Stark and the combination of my coming in and solidifying his terms. Okay, now a lot of people, oh, your document has mistakes in it, the contracts. Exactly, because we can't write the contracts for you. I cannot write a contract for you because then you wouldn't be able to use the agency that we put together to help you with the contract. There'd be too big of a conflict of interest. So the only thing we can do is provide a template, the same as all these other companies provide templates. All these lawyer agency and offices provide templates. You want to do a motion for this? Well, they'll provide you a template for that motion. Well, we can do the same thing. Okay? You just have to make it applicable to your situation. So that's why we highlight the areas where you need to make it applicable. Other than that, for the most part, you can leave it alone. Even if it has some typos. And the typos are there on purpose. Even if it has some typos, guess what, ladies and gentlemen? That doesn't invalidate the document. Because it has specifically in a document that any misspelled words and blah, blah, blah shall not in any way affect the document because it's to be read contextually and not to be construed otherwise. Okay, that's what the document says on purpose. All right, Ladies and gentlemen, thank you for allowing me to take up an hour worth of your time. I got work to do. You know, that I got work to do. I got work to, that's what I got to do. I got to go do some work, y'all. So y'all take care. Goodbye. Adios. Arrivederci. Sayonara. You know what I'm trying to say.